sitting on a Constitution that never has been amended. There's been plenty of discussions about this, and if you're going to change it, change the Constitution. Don't do it with a statute that has no meaning, that would never get the light of day across the hall. I urge you to table the motion to recall.
Senator Macon.
Yes, sir. Senator, you for a question.
Yes, sir.
Senator, you brought this up, and it doesn't have to do with the motion, but tell me again why it takes 5 votes instead of 3 votes, because to put a roll call, because I thought our rules was 3, but they keep saying 5.
The rule 16 is, by rule, we can adopt, in my judgment, in the Senate's judgment, a lesser threshold. And we did that.
We adopted 3.
Yeah, we adopted 3 on a bill.
Why do we keep saying 5 then?
We do that for motions. Every time that's done from the podium, the 5 senators second a call. It's usually a roll call to adjourn or to move to table something. That's on a procedural motion, it's 5.
Well, what requires?
But on a bill, it's 3. And we did that by rule. We have the authority under the Constitution to, in my view, to do that. And we've done that. We adopted a very comprehensive Rule 16. And I think it's more comprehensive than the one across the hall. But if you want to change the rules, change the rules. If you want to change the Constitution, change the Constitution. But I am not going to sit by and involve the governor and the court in something that clearly falls within the province of this chamber. I'm just not going to do it.
Senator from Beaufort had been waiting for a long time.
Yes.
I just wanted to be heard again on the...
Okay. Senator from Cherokee.
Well, and like I said, I didn't intend, and Senator Beaufort, in all candor, I didn't intend to get into the extended debate on this, and I appreciated the Senate's indulgence in allowing me to be heard. But I do hope the fact that we set up a committee meeting, we don't intend to just sit on the bill and not let folks air their grievance. And if I hadn't had a committee meeting scheduled, I'd say, well, yeah, I mean, if I didn't know like we were going to get to it, it's a House bill, but we've got a committee meeting scheduled, and we'll let the process run its course.
Mr. President.
Yes, sir. Be glad to yield.
You have a question?
Yes, sir.
Chairman of the Rules Committee, if we recall the bill and amended it to mirror our rules, what would be wrong with that?
Well, again, you're involving the governor, you're involving the court, and all that goes along with that.
That's the part that pertains to the Senate, not the...
You can't apply a statute differently on the Senate. You would impose that statute differently on the Senate than you would the House.
Let the House deal with the House.
Well, that's what we're doing. It's the law. Let me tell you something. Rule 16 is the law,
all right,
in this chamber until it's changed.
If it's rock, paper, scissors, what beats? Rules or a statute?
The rules.
All right.
This body will abide by the rules, which are derived from the South Carolina Constitution, not from state law, but from the South Carolina Constitution. Article 3 of the South Carolina Constitution.
So
we don't. It's not that, and I don't mean to cut you off. It's not that long. It's a pretty cogent amount of reading, and you don't have to flip through the Code of Law, Section 1-58-53 subitem E. The point is that we've already done this. It's the law.
So my point is, if rules trump the statute, what's wrong with just making the statute mirror the rules, and that should satisfy the folks?
I don't understand.
I don't understand why you don't understand. I don't know.
I don't understand. I don't understand about this. That you don't understand that this is the law of this Senate right now.
If it is, then what's wrong with passing the statute? What's wrong?
Statute.
How does that affect us constitutionally?
Constitutionally, it has no bearing on what we do.
So
just like we changed the rule.
In the resolution to Congress, you say they throw it in the trash.
Well, you know, and the other thing about this, and I know people are going to be listening to our discussion. They're going to be podcasting this out on talk radio, and they're going to say, well, you know, Senator Martin is opposed to putting this in state law so those guys on a whim can't change it. Senator, you know how difficult it is to change our rule? Don't you?
I'm not talking about the rules. I'm talking about this bill.
You got to go through the legislative process to get the House's permission or concurrence, agreement, and the governor to agree to it. Why do we want to involve the governor in a Senate rule? When did we start doing that?
If the rule trumps all this, why are you concerned?
Well, it doesn't mean anything. There's no meaning whatsoever.
Let me ask you a question.
Yes, sir.
The next time my wife asks for $50 to buy something, I'm
Yes.
going to say, I can't do it. And she'll say, well, I'm going to say, it's unconstitutional.
Well, I wish I could impart to you just how serious it is that we derive our rules from the Constitution, not from the statutory law of this state.
Senator from Charleston.
Yes, sir.
Senator, I think I can answer the senator from Gaffney's question. Wouldn't you agree that really Article 3, Section 12, which gives to each body,
Each house.
the authority, to each chamber, the authority to establish its own rules, isn't that an application of the separation of powers doctrine?
Absolutely.
That is a specific application of the separation of powers doctrine. For the very same reason the courts establish their rules. For the very same reason. The court can establish orders, the court can issue orders for the procedure of operating the courts. That's what Chief Justice Toll does on a regular basis. And that is simply an application. The reason that the rule would trump the statute, as you said, is because it's provided in Article 3, Section 12 of the Constitution, but that, in the most general, big picture sense, that is a specific application of the separation of powers doctrine. That's why you said, isn't it, Senator, that's why you said, why do you want the governor involved in how our internal proceedings are going to be?
Exactly.
And that's because if you did it by statute instead of by rule, you're getting other branches of government involved in the internal workings of each of a particular branch, and because of the separation of powers.
And as you well know, there's a whole laundry list of cases that the court routinely cites in every decision. You go back to the 3 readings, the Bob Tailing legislation, those type bills, they go back and cite those as a basis for not reviewing how the enactment occurred, because they have no authority to go back.
Because of separation of powers.
Because of separation of powers.
Which basically is, and it doesn't the separation of powers doctrine, what that is, that's a doctrine that says there are 3 different branches of government.
Exactly.
And in the wisdom of the founding fathers, those who drafted the federal and the state constitution, they gave each branch certain devices that to trump and blunt the power and authority of the next, and that's why it's a great application. The separation of powers doctrine really is something that furthers the concept of limited government, doesn't it, Senator?
It does.
It does.
Well, the biggest thing it does, Senator, it keeps the court outside the sphere of reviewing the internal workings.
And it keeps us outside the sphere of reviewing the court, doesn't it?
Each member of this Senate, through our rules, is given the responsibility for ensuring that we follow our process. And that's one of the reasons the Senator from Charleston,
Senator from Anderson,
myself, and others routinely insist, when a unanimous consent request is made, you routinely insist on certain things be done a certain way, because that protects the right or the integrity of the process. Be glad to yield.
Would Senator yield a question?
Yes, sir.
I want to just ask a question about the motion more so than
Sure.
the bill itself.
Sure.
And I appreciate you committing that if the motion fails, the subcommittee is going to meet on this bill.
Yeah, well, I didn't mention this. Senator from Spartanburg, Senator Shane Martin, wrote me a letter, said, look, I'm meeting with these Tea Party folks, and they're very adamant that we get this done.
My question is, and I've seen many times when bills are placed on the calendar, yet they still go back to committee for review, maintaining its place on the calendar. We've done that before, haven't we, Senator?
That has no benefit in this instance. our contested calendar, this bill would likely be contested in the first instance.